Yojana to sunset.
Right, Sapna, thanks a lot for that. Let's shift our focus to one issue that's brewing between the judiciary and the executive. The government and senior members of the judiciary have been embroiled in a rather acrimonious stalemate for some time now, with the Law Minister Kiren Rijiju, who has criticized the judiciary for taking long vacations despite high number of pending cases, calling the move not very convenient for justice seekers. The CJI, meanwhile, has refused to relent. Justice Chandrachud, Chief Justice, said that the Supreme Court will not have a vacation bench for the winter break. Now, importantly, this brings us to a Law Commission report dating back to 2010, which had adopted the recommendations of Justice AK Ganguly, then a judge of the Supreme Court. Justice Ganguly had suggested curtailing vacations of higher judiciary by at least 10 to 15 days and extend court working hours by at least half an hour to manage the workload. Now, we have with us the man himself, Justice Ganguly. Justice Ganguly, a very good afternoon. Thank you so much for joining us here on CNBC TV18. Let me first take you through the 2022 calendar for the Supreme Court, the top court, the apex court. Just a simple reading of the calendar shows that of the 365 days, the court is on vacation on 177 days, which is nearly half of the year. There were petitions filed in the Bombay High Court which said that this is, in fact, a violation of our fundamental right to getting judicial access, that this is, in fact, benefiting only a very small elite group of jurists. What would your take be on this entire debate, and with now even the Law Minister saying that perhaps the vacations are a bit too much?
Well, vacations and courts, these are very vexed issues. Well, you must understand how severely hardworking the judges are. I mean, the Indian judiciary is the most hardworking judiciary in the world. You must understand that the judges not only work during the court hours, in order to deal with the heavy schedule of work, the judges have to work beyond court hours. Even in the morning before coming to court and in the evening after returning from court duties, they have to burn the midnight oil to read the papers, to prepare judgments. So when the court is open, it is not only the judges' working hours, is not only confined to the court hours, that is from 10 o'clock or 10:30 to 4:30. It is much beyond that. Therefore, the judges legitimately need some vacation. But as you rightly said in my recommendation, I had no power to recommend, but I wrote an article in which I suggested that the court vacation should be curtailed and the court working hours should start. We should start at 10 o'clock every day instead of 10:30. 10:30 has no meaning. You see, everywhere, the schools, the offices, they all start much earlier. And the first part of the day must be properly utilized. The court should start at 10, it should continue till 1. There should be a meaningful break for 1 hour. Then it should start again from 2 and should continue till 5. If you do that, then every day we are extending the working hour by almost 1 hour, which is substantial. And what I have suggested in my article is that the period during which the court is working, that should be controlled in the sense that the adjournments, the very well-known system of adjourning cases, that should be very strictly regulated. A civil procedure code has already stated. You see, if you look at Civil Procedure Code, that is already stated under Order 17 that an adjournment cannot be just granted just for the asking. This adjournment should be controlled. But unfortunately, without the proper assistance of the bar, this is not possible. See, in many cases, you find...
important points that you've made there. As a part of the recommendations also that you forwarded to the Law Commission, they in fact adopted your suggestions there in their report, in the 230th report of the Law Commission. However, just from a layman's perspective, the concern that often emerges is that there are various disciplines in the country, professional disciplines, which dedicate a lot of time for which take a mental, physical toll on one. But this is one profession where there is a summer break that extends for as long as 7 weeks. There's a winter break that extends for 2 weeks. Then there are Holi break, Diwali, the Dussehra break as well. The concern that has emerged from Mr. Rijiju's comments is that is there room for perhaps debate and discussion on reducing the leaves at play? We're talking about Supreme Court working only for, or leaves accounting for 177 days out of 365. You yourself had suggested reducing it. Is there scope for that discussion, for reducing the summer break?
Yes, certainly, because the summer break, which is for such a long period, that should be reduced. Of course, during summer break, the Supreme Court functions. It functions during the holidays also. There are holiday benches where regular matters are taken up for hearing. But a regular court should be there, because the holidays for 7 weeks, I mean, should not be encouraged in the context of the large pendency. You see, in other countries, the court doesn't work for more number of days. But there, the pendency is not so much. The judge population ratio in India is extremely poor, apart from the vacancies which are already there, which cannot get filled up for various reasons. The sanctioned vacancy in India of judges is not that is not filled. That's very important.
Indeed.
The judge population ratio
that's an interesting point that you point out in terms of
extremely poor, extremely. You see, in my view,
sure, Justice Ganguly, that's a very relevant point. Yes, Justice Ganguly, that's a very relevant point that you've made in terms of the judge per population gap. And that is, in fact, a point that has emerged in very recent cases and hearings that we've seen before the top court on judicial appointments. That is where we've seen, for lack of a better word, a very ugly exchange between the government on one hand and the apex court on the other, where both sides are trying to pin the blame on the other. What do you make of this public debate that is now spewing out into the public domain via social media and via newspapers and publications, which in fact reflect kind of a breakdown between the two sides?
See, both sides should consider their duties more seriously, if I may say so. The judiciary should be like an open book in an open society. Everything should be marked by accountability and transparency. You see, if you permit me, I shall quote from a few lines of what was written by Harold Lasky. If you permit me, the lines are so pertinent. Lasky wrote centuries ago, obviously, therefore, the men who are to make justice in the courts, the way in which they are to perform their function, the methods by which they are to be chosen, the terms upon which they shall hold power, these and their related problems lie at the heart of the political philosophy. When we know how a nation state dispenses justice, we know with some exactness the moral character to which it can pertain. So these are very serious issues. Neither side can afford to be simple. You see, the appointment of judges and the performance of the judges, these are issues which should be transparent, accountable, and must be marked by the principles of judicial independence. The present system of appointment of judges is the best system available. Because we have found when the power was in the hands of the executive, what happened? Eminent judges like Justice Khanna, Justice Hegde were superseded only because of one reason, that their judgments were not to the liking of the executive government at the time in power. We do not want that thing to be repeated. At the same time, the judicial appointment in the hands of the collegium system presently functioning is not satisfactory either. On many occasions we have found, because of nepotism was taking place, there are various approaches where best person has best talent has not been chosen. So a compromise has to be made. But
Justice Ganguly, we're running out of time. I'll just ask you one last question, Justice Ganguly. We're completely out of time, but I'll ask you one more question. And I'll just quote a few statistics here. Ever since Chief Justice Justice Chandrachud took over, the number of cases filed, 5,898. Number of cases decided, 6,844. And this is on account of a certain sense of discipline that Justice Chandrachud is trying to bring into the apex court. Is this the way forward? Do we already have a model that works within the framework, within the four walls of the infrastructural constraints that we have?
Justice Chandrachud, prior to him, Chief Justice Lalit, they have all tried to form certain system, certain discipline, which has worked very, very effectively in knocking down the area. That should be followed and should be followed by all courts, even the district courts.
Right, so I think we